Ladies and gentlemen, welcome back to our uh, course, which is paralegal uh, counseling. Paralegal counseling. Today, um, we are going to look at wills and estate. We'll look at wills and estate. That is what we are going to concentrate on today. So, in this topic, we are going to concentrate on number one, legal meaning of will and estate. Number two, we'll look at two types of estate. Number three, we'll talk about freehold estate. And number four, we'll talk about non-freehold estate. So this is what we are going to discuss this morning. I believe that everyone is following and you're going to be close attentively and also be able to write the assignments that are going to be given to you. Once again, my name's Dr. Sakala William, the project coordinator of Vision 2025, and also I'm the one coordinating this program of this training. Thank you so much. God bless you. Okay. What is the meaning of estate in law? The definition of estate in law. So, in law, it states that all the land, all the money, and the property owned by a particular person, especially at death. All the money and the property owned by a particular person, especially at death. That is what is called estate. So estate, these are monies, the properties, everything that a person owned during his time of living on earth, particularly at death. That is what is called estate. There are two types of estate. Number one is freehold estate. This is an estate involving ownership. A freehold estate is an estate involving ownership. Number two, there is what is known as non-freehold estate. A non-freehold estate is an estate involving tenants. A non-freehold estate is an estate involving tenants. Definition of will in law. Definition of will in law. It states that it is a legal document in which a person, the testator, declares their intention as to what happens to their estate after their death. It states that it's a legal document in which a person who is the testator declares their intention as to what happens to their estate after their death. Okay, there are some terminologies here which I'll be able to send a will glossary terms, so that you'll be able to, at your free time, you'll be able to understand some of the terminologies that may be new to you. So I'll send immediately after the this train, the voice notes. I'll be able to send the glossary of terms. Okay, so that is the definition of a will in law. Okay, so regular. Okay, pardon. Regardless of types of wills, a valid will, number one, must be in an approved form under state law. It must be prepared in an approved law under state law. Number 2, must be created with testamentary. It must be created with testamentary intent. Number 3, the testator must have testamentary capacity. A testator must have testamentary capacity. Number 4, the requirements for formal execution must be met. All the requirements for formal execution must be met. Without all these, the will may not be valid. The will may not be valid. Generally, there are 3 types of wills. Generally, there are 3 types of wills. Number 1, it is called holographic will, which is also known as handwritten will. And number 2, it is called standard will, which is also known as a typed and printed will. Typed, this time you just type and save it just like that, but it can also be typed and printed. That is the standard will. And the number 3 is partially handwritten and partially typed. So these are the 3 types of wills. Before we proceed, I would love to make us understand that God has left with us a will. God has left with us a will, which is a New Testament. The New Testament is a will of God, which He wants us to follow. Okay, it is the word of God, the word of Jesus Christ, which He left with us before He went to be with His Father in heaven. So a will is a document that is left behind by a deceased. That is a will. Can be invalid if, number 1, not signed properly. If it is not signed properly, it can be invalid. A will can be invalid if, number 2, destroyed. If it is destroyed, the will can be invalid. It can also be invalid if it is altered. That is number 3. If it has been altered, then the will can be invalid. The will also can be invalid, number 4, if the testator not in sound mind when writing. If the testator not in sound mind when writing. A will consists of various things, but the 5 major areas are the ones that we are going to talk about. Number 1, name and information regarding the testator. Number 2, name and power of the executor of state wills. Name and power of the executor of state wills. Number 3, appointment of legal guardians through family law advice. Appointment of legal guardians through family law advice. Number 4, listing the legal assets for assets prevention. And number 5, information regarding testator. Information regarding testator. So these are the 5 important things which a will is supposed to contain. The golden rule in a will is that the golden rule is that a will outline that when a solicitor has doubts as to the capacity of client wanting to make a will, medical opinion should be sought. When a solicitor has doubts as to the capacity of client wanting to make a will, medical opinion should be sought. Definition, definition of, definition of estate property in law. Definition of estate property in law. It states that all rights, title, and interest in and to any and all property of every kind or nature owned by either debtor or their estate on the day of petition. It means all rights, title, and interest in and to any and all property of every kind or nature owned by either debtor or their estate on the day of petition. Which simply means that all the debtor's property created in the case, including all property in which the debtor has interest in. Earlier on, we had talked about freehold estate and non-freehold estate. So, freehold estate, when you own a freehold estate, you have exclusive rights for an undefined period of time. There are three types of freehold estate. Number one, fee simple absolute. Ownership has complete ownership. The owner has complete ownership over the property without restriction. Owner can pass to heirs. This is an estate where it can be passed to heirs because the owner has got all the rights. Number two, fee simple divisible. Fee simple divisible. It puts more restriction on the owner owning the land, comes with conditions. Owning that land or owning that property comes with the conditions. For example, you may have to use a property for a specific purpose. If you don't follow through, you could lose ownership. So this is a property where you have rights to use or rights to use the property have been described to you. Specifically how you should use that property. And if you do not follow, you may end up losing the property or ownership. You may end up losing ownership. Number three, life estate. This is a type of a freehold estate that is something to consider during estate planning. People want to give their homes to their children when they pass on, when they die. Life estate is property ownership where ownership ends when property ownership where ownership ends when you die, and you can pass it to your heirs. Types of non-freehold estate. Types of non-freehold estate. A non-freehold estate is a real estate that you have a limited occupy but don't own it. You have a limited occupants but you don't own it. They are also called tenancies. Non-freehold estates are also called tenancies. So there are about 4 types of non-freehold estate or tenancies. There are about 4 types of them. Number 1, tenants for years. Number 2, tenants or tenants from period to period or periodic tenants. Number 3, tenants at will. And number 4, tenants at sufferance. So, tenants for years is a type of estate created by a lease you have. You have it for a fixed amount of time. It outlines the beginning date and the ending date. That is a tenants for years. Number 2, tenants from period to period, a periodic tenants. These are leases that do not have a defined end date. The agreement is renewable. Both parties can also agree that notice is necessary before the lease is terminated. Number 3, tenants at will. The 2 parties do not use a binding contract or lease. The agreement also doesn't typically specify the occupants, time, length, or the way that the payment is made. These are types of tenancies that are normally there, which we normally use, where you agree with the landlord, where there is no proper documentation, no proper agreement with the landlord. You just find a property and then you are just told you have to pay so much, and then you pay, then you get into, without proper documentation, without a proper agreement, the period in which you have to be in that period you have to use that property, and also how you for example, if you want to leave the property, the condition there. So normally this is the kind of the tenancies which are very, very common out there. Number 4, tenants at sufferance. Tenants at sufferance. This kind of tenants, it does not occur under a contract or lease. It is a type of tenants that takes place after the tenancy's lease expires, but before they leave the property. So this tenancy occurs after the tenancy's lease expires, but before they leave the property. So during the time when the tenancy expires, and then you ask the landlord to give you some time before you leave the property. So this tenancy works well under the landlord permission. This tenancy works well under the landlord permission. Number 4, tenants at sufferance. Tenants at sufferance. This kind of tenants, it does not occur under a contract or lease. It is a type of tenants that takes place after the tenancy's lease expires, but before they leave the property. So this tenancy occurs after the tenancy's lease expires, but before they leave the property. So during the time when the tenancy expires, and then you ask the landlord to give you some time before you leave the property. So this tenancy works well under the landlord permission. This tenancy works well under the landlord permission. Well, thank you so much for your time today. This is where we end for today. Tomorrow when we come, we'll concentrate on the administration. We'll concentrate on administration, that is administering estates. Administering estates. That's what we are going to look at when we come back tomorrow. Thank you so much once more. My name's Dr. William Sakala. Thank you for following and for being with us. May God richly bless you.